This is Adam Turk from Fenton Goldman Turk and Davidoff. I wanted to take a moment to update you on a change to real property law insofar as it pertains to the Property Credit Disclosure Act. These changes go into effect on March 20th, 2024. The Property Credit Disclosure Act requires a seller to give a buyer a Property Credit Disclosure Statement, a PCDS. This statement is filled out to the best of seller's actual knowledge and is intended to disclose issues which may not be readily observable by visual inspection. Many of you watching this video might be saying, I've been in real estate for many years. I have never seen such a form. Up until now, the seller, instead of filling out the PCDS, was allowed to simply give a buyer a $500 credit in lieu of the form. This credit is standard procedure. As of March 20th, 2024, the $500 credit option is going away. Sellers now must fill out a revised PCDS consisting of 56 different questions. The new form can be found on our website, fentongoldman.com, under the Real Estate Resources section. Some updates from the old form include questions regarding the property's flood status. A PCDS is only required when the property being sold falls under the residential real property legal definition, which is real property improved by a 1 to 4 family dwelling used or occupied as the home or residence of one or more persons. It does not refer to vacant land, condos, or co-ops. There are still circumstances for real property where a PCDS is not required. There are 14 exceptions, the most common being selling out of a trust, pursuant to a divorce decree, selling to a close family member, selling to a current co-owner, or any new construction home. When a seller fills out the form, they must answer all 56 questions. The answers can be yes, no, or not applicable. The form must be provided before contract signing. The standard for answering these questions is seller's actual knowledge, not what sellers should know or could know through investigation, simply what they actually know. The PCDS does not replace a buyer's due diligence. It is not any type of warranty for the buyer moving forward. The old rule of buyer beware still applies. Real estate agents and brokers, you cannot fill this form out on behalf of your sellers. They must do it themselves. It is your duty to inform them of their obligations. Buyer's agents, you have the same duty to inform your buyers they're entitled to this form. If there is no buyer's agent, the seller's agent must inform the buyer as well as the seller. There are other nuances to these updates and changes, but for the sake of keeping this video short, I won't go into them here. I am happy to discuss them further with you another time. Please feel free to reach out to me via phone 212-265-4900, email aturk@fentongoldman.com, or on social media. I'm on Instagram at AdamSethTurkESQ. You get to see some great pics of my kids and my dog as well on there. Like all updates to the law, time will tell how these changes affect how we conduct our business. Hoping to see you all on a deal soon. Have a great day.